Good morning and welcome to today's webinar, Supported Decision Making for Loved Ones with Disabilities, Breaking Through, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's presentation. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. We have many new attendees in our presentation today, which is great to see. And if you're coming back to see us again, thank you as always for your interest and support. So you as the attendee are currently in listen only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address all your questions. Your questions really help the presentation and add value. They help others learn. So please don't be shy in posing your questions at any time. Also, you received the presentation and sample supported decision-making agreements yesterday by email from me to take notes on them if you wish. If for some reason you did not receive the presentation, it is available in the section marked handouts in the panel on your screen to download at this time. For our professionals on today's webinar, welcome as well. For CFPs, CPAs, and others on today's webinar, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval, which I plan to do tomorrow morning. Everyone will also receive a post-webinar feedback email right after the presentation. And we do ask that you please just take a couple minutes to fill out this very simple survey to offer us your feedback about today's presentation. We read and value every comment, and it's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have. And we always here at Elville & Associates look forward to being a resource to you in any way. So briefly, as we have a lot to cover as always, I'd like to offer you an overview of our firm and share a little bit of Steve. So you should be able to see my screen at this time. So Elville & Associates, for those of you who aren't familiar with us, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We offer many different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Stephen and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We focus on education a lot here at Elville & Associates, and we think that's one thing that makes us a bit different from other places out there. We do that in several ways. Through our planning processes with our clients, through over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we like to call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at the firm. A little bit about Steve. His work as an attorney for the past 20 plus years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 7th time in 2022, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn a little bit more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me, and I'd be very happy to share our story with you when we have a little bit more time. So with that said, we're going to go ahead and jump right into the presentation. I'm going to go ahead and pull that up, which should take me just a moment here. And you should be able to see it. Steve, do you see that presentation?
I do. Thank you, Jeff.
Okay.
All right. Well, thank you, Jeff, for that introduction, and good morning, everyone, and holiday greetings to you on this Thursday. So happy Thursday and happy holidays to you in advance. I hope that you're enjoying this beautiful day as I'm sitting here at Elville and Associates Conference Room number 1. I can see outside and how beautiful it is. And thank you for spending your valuable time with us on this Thursday morning. And I just want to say before I begin, I couldn't do what I do without the associates and staff here at Elville and Associates, including my longtime colleague, Jeff, who is our moderator today. So thank you, Jeff, for all you do. Jeff is a very seasoned moderator, so if you have questions, please let him know. He will interrupt me in this important presentation, but he'll interrupt me intentionally so that I can address questions and hopefully be of a general resource here for questions this morning. But otherwise, this is an informal presentation, so I want you to relax. And I want you to now understand something that I'm going to attempt to explain about this. I am very privileged and humbled to be able to bring this presentation to you this morning. There are people who made extraordinary efforts, at which we will discuss here shortly, to get this legislation passed in Maryland. And now we have supported decision-making for persons with disabilities. So I am very privileged to work in the special needs or disability community, and very privileged to be able to present this morning. So with that said, we're going to educate, give you this information as a resource, but as I will explain here in just a few minutes, this information is simple in some ways and yet complex to understand in other ways. And I'm going to talk about that and try to lay this out as a substantive resource for you to refer to in the days ahead, in the months ahead, now that supported decision making is the law in Maryland. So with that said, we're going to get started. So Jeff, let's go to the next slide. And of course, everything in this workshop this morning doesn't really represent legal advice because we're not able to render legal advice by way of a webinar, but we're educating and giving you general information about this topic. So we're going to talk about what it means to understand supported decision making. What is it and what is its purpose? Okay, this is new legislation in Maryland effective October 1st. So you are really at the crest here. You're at the beginning of this process in Maryland, and we're going to see how this unfolds. We're going to talk about what the promise is of supported decision making, and I'll occasionally slip into using the acronym SDM, supported decision making. We're going to talk about what supported decision making is not, as a way to try to get our minds around this. And if you're not familiar with this subject, it will take a while. It will probably take a little while to start understanding what this is all about and what it means to you and a loved one with disabilities. What is its relationship to powers of attorney? What is supported decision making in relationship to advanced medical directives and guardianship? We're going to try to unravel this morning. How does it actually work for persons living with disability? And we're going to review Maryland's legislation. So one of the biggest things that you'll see in this presentation, which is the more tedious part, I would say, but important part, is we're going to parse out the actual legislation. The legislation is not complicated. And as a matter of fact, I wrote an article in our most recent newsletter. We're getting ready to put out a new newsletter for the fall and winter, but in our prior newsletter, which is available to you, I wrote a fairly long article about supported decision making, and I lay out much of the legislation in there. So always know that you have the newsletter to also refer to, and a rather long article to really help you absorb the scope of this legislation. We're going to review some various supported decision-making agreements and just let you know what those look like. And of course, in Maryland now, we can create our own supported decision-making agreements, which we'll talk about. And we'll talk about next steps, and we'll take more questions and answers and provide answers. All right, Jeff, let's go to the next slide. Okay, so let's talk about what supported decision making is and what its purpose is and what its promise is. So I'm just going down these bullet points. Supported decision making is a tool. It's a tool for persons with disabilities where they can be empowered and they can have support in making their own decisions to whatever extent possible. So let me give you my definition. My definition, and you can create your own, of course, is that supported decision making is a tool that allows persons with disabilities to make their own decisions, to whatever extent possible, provided that they have the support to do so. And that's the whole thrust of this. So it's a very simple concept when you think about it, but it does have more complex ramifications. Now, this can be a simple written agreement, or as you're going to see with the Maryland law, there doesn't have to be a written agreement at all. And this is going to be so broad after we waited so long for this legislation that some people don't know what to do with that. Some people don't know how do I think about this? It's not going to be a written agreement, it's a verbal agreement. And as you're going to see, it can be several supporters and not just one supporter. So very simple concept to allow people with disabilities to make their own decisions under the law, officially recognizing that. But now we start to immediately see how broad the legislation is. So this is a formalization of this authority for a person with disabilities to be recognized as someone who can make their own decisions. It is an alternative to adult guardianship, which we're going to talk about, and it's a potential addition to, financial powers of attorney and advanced directives. We're going to talk about that. It's a potential tool in guardianship. So yes, a person can be under adult guardianship and still have a supported decision maker under Maryland law. So that is a mind-boggling concept for many of us who are used to this prior paradigm. And that gets to the next bullet point. This is part of a huge paradigm shift. And every person, every supporter, every parent, every loved one that supports a person with disabilities, every person who works for an organization that supports persons with disabilities is really going to have to get their minds around what this paradigm shift means. And we're going to talk about this. It is a new world of self-determination for those with disabilities. And notice here, I am saying those with disabilities, young or old, someone in the aging community, someone who is young, someone who has cognitive disabilities or other aging related disabilities. So this is very broad and it does not apply just to those individuals with traditionally thought about cognitive disabilities. Okay, Jeff, let's keep going. So there were key players that I was referring to in the beginning of this presentation. Those key players in my world were Megan Rusiano of Disability Rights Maryland as the main thrust, the person who should be given the most credit for having passed or caused the passage of this legislation, along with those individuals that she worked with. So I met Megan several years ago at the Arc of Frederick. And ironically enough, I was presenting on guardianship in the same presentation where she was juxtaposing that with the new concept of supported decision making years ago. And Megan came from the places like British Columbia, where she had lived and worked with supported decision making. And now Maryland, finally, after many years of effort on the part of Megan and others, Maryland now joins many, many states that have supported decision making, including Delaware, DC, the District of Columbia, which have had supported decision making long before Maryland, Wisconsin, Indiana, Alaska, Texas, and many other states. So this paradigm shift from a paradigm of protectionism, which we're going to talk about in just a few minutes, and shifting to this new paradigm of self-determination has been long overdue in the law. This is something that has come down from the United Nations, as you see on this slide here. I got a little ahead of myself there talking about the various states. And again, this is a departure from the old paradigm. The United Nations says, the United Nations mandate says that persons with disabilities have the right of self-determination, just regardless of their disabilities. So this old paradigm was very, very difficult to switch from. and very, very difficult for lawmakers and attorneys and legislators in general, legislators in general, to understand. And I remember several years ago, wonderful elder law attorneys here in Maryland just really having a hard time allowing themselves to think beyond the old paradigm. But now we have gotten past that, and there are some legitimate fears. There are legitimate fears of change, legitimate fears of fraud and abuse. But as Megan has illustrated in her efforts in educating many of us and educating the public, hopefully with this new paradigm and with the right amount of oversight and good faith, these things will be kept to a minimum. But we have to have a healthy awareness of these possibilities. Okay, Jeff, let's go to the next slide. Now, I'm kind of intentionally going over the same information here a couple times. Intentional redundancy, Jeff and I like to call this. Why was SDM so needed in Maryland? Well, there was no good alternative to guardianships versus powers of attorney. So let's talk about that for just a couple of minutes here. So we're going to talk about this a little further, but we had people that had higher functioning capacity, higher functionality, I should say, in their disability, but they had the mental capacity to be able to sign and execute and understand powers of attorney and advance directives as alternatives to guardianship. And then we had those people, and we still do, of course, that cannot execute powers of attorney or advance directives, or should not. They don't have the capacity to do so. And those individuals under the old paradigm would have no real alternative except guardianship as a process. And in the guardianship process, we would have full-fledged guardianship, which means a loss of legal rights. And then we would have those circumstances that were more ambiguous, and our premier guardianship attorneys in the state of Maryland would show us that many of these guardianships would result in what is called consent agreements, or agreements that are short of guardianship. So these crafted agreements were the only thing that was the only thing that these guardianship attorneys could do to try to craft some kind of agreement about the support of the person without the full loss of their legal rights. So that was the only real paradigm that we had in Maryland. And now we have supported decision-making as an alternative to guardianship and an addition to guardianship if guardianship is needed, but also over here with powers of attorney, an addition to powers of attorney. So a person, as we're going to talk about in a few minutes, can have powers of attorney and advance directives and still have a supporter and a supported decision-making agreement. A person under guardianship, if the guardian consents and so forth, as we'll see in the legislation, can have a supported decision maker. So there was no formalized way for persons with disabilities to be supported other than these crafted agreements. There was no, and still is no, annual review of private guardianships. So someone could be under a guardianship that was not a public guardianship, and there's no review. And there was no clear alternative and no real way for it to be explored or implemented. And there were inconsistencies in the law. So our guardianship attorney friends would say, you know, the court is supposed to examine all lesser restrictive alternatives to guardianship, but that really wasn't happening. So these old notions of traditional guardianship and the inequity of those, that culture is no longer needed. And the culture, I was saying, as the culture of paternalism, this is something I just kind of coined as far as this old paradigm of paternalism and mitigating risk. What it did is it hurt the potential of persons with disabilities. So we're talking about the concept, we're talking about the theories of it, and one of the challenges we're going to find is that parents and other supporters are going to be somewhat confused by this and how to go from point A to point B now that we have supported decision making. It's a given that this is a shift in paradigm. It's a given that it's a step away from the culture of paternalism, but now the question is, what do we do? Okay. Now, again, going back to the way things were just 30 days ago, we had appointments of financial agents under powers of attorney. The appointment of the agent, as long as we have agents and those agents get along together and cooperate toward the best interest of the person who is the principal, giving the authority to that agent, we know that that is an alternative to guardianship. Appointment of a healthcare agent, that is the alternative to a guardianship of the person, and the appointment of a financial agent is the alternative to guardian of the property. The appointment of a representative payee, someone who is receiving Social Security, has a representative payee. These were the tools available, and still are tools available, to avoid guardianship of the property. Joint ownership of assets avoids guardianship of the property. Surrogate decision-making, the ability for a surrogate who is listed in the order of priority in the Maryland Code, is an alternative to guardianship of the person. And of course, other than those tools, we had traditional guardianship of the property, traditional guardianship of the person, and then I mentioned just a few minutes ago the consent orders. These were the prior tools, the prior paradigm. Okay, Jeff. Now I'm going to stop right here now, and just as a brief pause to give you a moment to think about that and to breathe a little bit. And this is where I'm going to articulate what I think the challenges are now as we get into understanding what supported decision-making is and what it is not. And that is that this is a wonderful shift conceptually. It's a wonderful shift in the furtherance of human rights and the furtherance of self-determination of those with disabilities, and a formalization of that. But what we're going to find is that there are supporters and parents who understand this. They are very supportive, they are proactive, they are looking at terminating guardianships if it's possible, or if guardianship does not need or should not be terminated, to implement a supporter under guardianship so that the person under guardianship has a supported decision maker. And for those who are thinking about petitioning for guardianship, thinking about supported decision making as the proper alternative that it should be, and for those with higher functionality and mental capacity, making sure that in addition to powers of attorney and advanced directives, that there is a supported decision making agreement. So thinking through all these issues, what does it boil down to in a way? It boils down to the person with disabilities having the right to take risks, the right to actually risk as they exercise their freedom and their new recognition of rights under the law. So this is going to be a wonderful thing to certain people as they get behind their loved one with disabilities. It's going to be threatening to others. It's going to be confusing to others. And it's going to represent just this big change where some people will simply not know what to do to help support the person with disabilities in this new way of thinking, as the best way that I can describe it this morning. So I have put together, just to help those of you who might be interested in really understanding the confusion here about when I speak to some audiences about supported decision making, I find that the audience is somewhat confused by this whole notion of where do we go with this from here? What does this mean for my child or my grandchild or my brother or sister who is disabled? What do you mean that they can now take risks? And what does this mean for them and for us? I have put together a very short documentary style film on this subject, and hopefully it would do, if nothing more, it will lend some understanding to this dilemma that I know many of you will encounter. If you're an advisor on this webinar, your clients may encounter this conundrum. If you are a social worker or a potential client, or whoever you are on this webinar, and whatever way that you're experiencing this information in your own life, to whatever extent that this may help you, please let us know if you want to see this short film. We will send it to you. We will send a link to you, and in this way, hopefully clarify a little bit more of what's happened with the law, what it is, and what the dilemma is for some people. And again, not everyone will have this dilemma. For example, many people with disabilities will not even understand their new rights. And so it's incumbent upon others to make sure that their rights are exercised, or that they have the opportunity to exercise those rights. And again, this short film is just to try to help understand for those who are in this dilemma of where to go with this, some direction. Okay, now let's talk about what supported decision-making is not. So supported decision-making is not a financial power of attorney, okay? It is not a way for a third person to make decisions for someone else. So remember, supported decision-making says that a person with disabilities, in essence, has the right to make their own decisions to whatever extent possible, regardless of their extent of disability, the extent of their disability, assuming that they have the support to do so. Okay, so this is something I'm really drilling down on so that we're clear about this. It is not giving authority to a third person to do whatever they want to do. So this is not a giving authority to someone and saying, well, you do whatever you think is best. That's not what this is. It is not a mechanism where the person with disabilities gives up any of their rights. It's actually to the contrary. And it is not adult guardianship, although, as I've mentioned several times, it can be a part of adult guardianship. All right, Jeff, let's go to the next slide. Now, what is the difference? And remember, I'm really drilling down here. What is the difference between supported decision-making and guardianship? Well, in guardianship, and many of you on this webinar have a loved one that may be under guardianship. Guardianship is usually the complete removal of rights to a person's property, their right to their own property and what to do with it. It's a complete removal of rights for a person under a guardianship of the person, where they don't have the right to determine where they live or their health care. And with some exceptions, because courts will allow a person to maintain the right to vote if it's specifically asked for. It's usually the loss of rights, I should say, to vote. In guardianship, there's really no legal choices unless it's crafted into the guardianship agreement. It is the paradigm of protectionism or paternalism, as I like to say, where there's no recognition of rights to take risks. Now, of course, under guardianship, a good guardian will allow the person under guardianship to have a say in their affairs and to respect their rights, because even a person under guardianship does retain some bare minimum rights. So when we say it's a removal of rights, it is not a complete removal of all rights, but mostly all rights, if that would make any sense to you this morning. But under guardianship, we have no recognition of the right to take risks. There is a fear of failure, a fear of allowing the person with disabilities to fail. There's no review of guardianships if it's under a private guardianship. There is review of public guardianships, okay? And there is this unspoken feeling or consensus that a guardianship is permanent. Many of you may have asked this question of yourself or someone else, and I have people ask me this question all the time. Steve, is guardianship permanent? I just had a longtime ward under a guardianship email me, and this person said, Steve, I haven't really talked to you in a while, but I want you to know that I am better, and I have 2 physician statements that say that I am now, I do have mental capacity. I am not incapacitated mentally. And so that person, if they do have that proof, that person who is under guardianship could petition the court and should to have the guardianship removed. But there is an unspoken consensus that guardianship is permanent. Okay, let's go to the next slide, Jeff. Now, in supported decision-making, as opposed to guardianship, there is no removal of rights, no removal of rights. There is a potential for the restoration of rights, just like I mentioned with that example, this real-life example that just happened in the last week or so. The right to the person's property and to their person and the decisions about their person remain vested in the individual. So it does not get transferred to a guardian, or with the court, of course, being the ultimate guardian under guardianship. In this paradigm of risk, instead of the paradigm of protectionism, there is the right to maintain your own decisions. So this is the right to fail. Again, causing a lot of confusion among individuals with loved ones with disabilities. What do you mean the right to fail? What does this mean when we're no longer here? What is this going to mean for my loved one? Who is going to be the supporter? How do I know that the failure is not going to be catastrophic? Very serious questions. It's an addition. It's an addition to financial powers of attorney. It's an addition to advanced medical directives for the person who has the mental capacity to execute those documents where appropriate. And it can be in addition to guardianship. I remember before supported decision making was passed in Maryland, I was always very envious of the laws of states like Indiana, where I thought, gosh, they're very forward thinking, and you can have a guardianship and still have a supported decision maker under guardianship. Well, lo and behold, that's what we have now in Maryland. Okay, Jeff's already gotten us to the next slide. Now, I'm going to take a little breather there. Jeff, I'm going to ask if there are any questions and just take a brief pause. I know this is very, very heavy information going fast and furious.
Thanks, Steve. We do have a couple of questions here. We have a lot of interest in the documentary film that you alluded to, so I think I'd like to send that out to everybody. So we do have one of our good clients that emailed me a question beforehand. I'm going to go ahead and read that first. My husband and I have guardianship of the person for my son. He is 35, and we would like to add SDM to his guardianship. How do we go about doing this? Will he be able to vote with guardianship and SDM, or would we need to dissolve the guardianship and just have SDM in place for him so that he can have his voting rights restored?
Well, thank you for that wonderful question, and good morning to you. I'm going to answer that very generally, of course, because we have to look at the facts and circumstances, but we also have to remember that this is a new tool for judges. This is a new tool for the guardianship court. So we really don't know how they're going to use this, and we have to assume, because I saw a wonderful video on the judiciary website about supported decision making. It was more of a practical video, so I encourage you to look at that as well. But now the law says, well, gosh, someone under guardianship can have a supported decision maker. So I think it starts with you as guardian saying, yes, that you're okay with this, that you agree and you consent. I also think that what you're going to need to do is petition the court to ask that the court appoint a supported decision maker. And so we're just going to have to see how that evolves, because this is really brand new. You are right at the cusp. And as a part of that petition, you're going to ask the court to allow the guardianship order to be modified, is my best guess, having not seen this in some time, of course, with you, and ask the court to restore the right to vote and make any other modifications you would like. So to my mind, this is a modification of the guardianship order to allow for a supported decision maker. And this is just going to be very fascinating to see how the court is now going to use this tool.
Okay. Next question. In Maryland, a person under guardianship of the person, they can't vote. That's in the form of a question.
Yes. So generally speaking, the guardianship of the person, which is very common when someone, especially a young person who turns 18, let's say, and the parents are petitioning for guardianship, it's usually the guardianship of the person, and the court frowns on guardianship of the property unless the person has actual property in their own name above and beyond Social Security income, or in the modern world, if the parents want to establish an ABLE account, Achieving a Better Life Experience account, and they have not previously done so, then a guardianship of the property is going to be needed, generally speaking, to be able to open an ABLE account for someone who's over 18 and is going to be under guardianship. But with that said, back to your question, generally the guardianship of the person involves the loss of the right to vote unless you specifically ask for that to be maintained.
Okay. And two of the exact same question at the exact same time. What is the difference between a private and public guardianship?
That is a great question. So a private guardianship, in a very simple way of thinking, is a family member brings a guardianship action to get guardianship of another person. whereas a public guardianship has to do with someone in the public domain. For example, the guardian of last resort, such as the Office on Aging, being the guardian for someone. So that is an example, very simple example of a public guardianship.
Okay. And last question for now, is there a supported decision-making in the state of Florida? I am legally blind and in my 60s, but I have full mental capacity and I don't like the durable power of attorney. In Florida, can I replace durable power of attorney with supported decision-making?
Thank you for that wonderful question. I am not barred in Florida, but hopefully will be in the future. And so I cannot answer for Florida law. However, it'd be very easy for us to get back to you if you were email us and ask us this question, and we can let you know whether Florida has supported decision making, which I'm pretty sure that it does. And we can connect you with a Florida attorney along those lines.
Okay, just had another one come through if we have time for that. My son has the capacity to understand a power of attorney and sign it and healthcare proxy, knowing he is giving us permission to help him make decisions but he doesn't make good decisions concerning his health and safety. So I'm wondering, what does a supported decision-making agreement add as a benefit to our current situation when we always support him in making his own decisions, as long as he's not putting his health or life otherwise at risk?
Well, thank you for that. And I would just say, first of all, congratulations. Your child is a very lucky person to have you, because you are doing already, prior to the implementation of supported decision making, you're already doing what needs to be done. You're already that supporter, and you're facilitating his right of self-determination. In so many words, very short words here, what this does is it puts a formalization, an umbrella, or a wrapper, I should say, of formality around it, so that when you are no longer here, and I know that's hard to think about, but you are doing all of those wonderful things, but this facilitates the ability of your child to be able to have a future supported decision maker and have it recognized under the law. So if you can think about a very simple example, you go to the bank, and let's pretend that your child has a bank account, and I'm just making that up. You're going to the bank, and maybe in the old days, there's no recognition of personal or otherwise, no recognition of your child as having the right to be able to just deal with his own bank account. But now, under supported decision making, there is this notion, it's a conceptual notion, this notion that he has the right to do this if he could do it. And he can do it, let's say, on his own, or he can do it with the support of someone else. And those folks at the bank have to recognize that. They have to officially recognize that. So these are nuances, but they are potentially huge nuances that I hope after today you'll be able to thoughtfully think through these ideas.
Okay, thank you, Steve.
Okay, and I think we're doing pretty good on time, Jeff, so I'm just going to keep plowing ahead. Financial powers of attorney and advance directives explained versus supported decision making. So I know I'm being redundant here. Remember, the agent acts instead of or on behalf of the principal. So in the example of the nice person who just asked that question, the child has a financial power of attorney, the child has an advance directive. They are the principal. And the agent acts for them when they are no longer able to do it themselves. Okay, so they have fiduciary responsibility. The agent has a fiduciary responsibility, and they have accountability. Okay, and the advance directive or the financial power of attorney can be terminated by the principal in writing. And this is the substitute for guardianship that I mentioned. All right, Jeff, let's go to the next slide. Now, with supported decision making, there is no agency relationship. So let's think about that now. The person who has signed the power of attorney or advance directive and appointed their agents, they are the principal. There's an agency relationship, and the agent has a fiduciary responsibility to the principal. But here in supported decision making, there is no agency relationship. The power of the principal, the power of the person who gives this authority remains vested in that person. The principal alone makes their own decisions with the help of the supporter. There is no authority under the new law for the supporter to act on behalf of the person. The supporter has to have accountability, and of course this depends on the jurisdiction and what state you're in. And the supported decision maker's role can be changed or terminated, and it is a substitute for guardianship. So let's think about that. Let's say someone is petitioning for guardianship of another person. Under supported decision making, the court must consider all lesser restrictive alternatives to guardianship, including supported decision making. And even though in the past, the person who is the potential ward under a guardianship, even though in the past they had the right to be present, they had the right to be heard, that was often waived by the court-appointed attorney. In this paradigm, the person should be heard. The court should listen to all potential alternatives to guardianship, including supported decision making. Okay, Jeff. Now, just to illustrate this, we know that powers of attorney and advanced medical directives are alternatives to guardianship, and they work wonderfully as long as everything works well and our agents get along with one another and the fiduciaries are able to act without any impediments, and that's going to avoid guardianship. Jeff, let's go to the next slide. And that is the whole thrust. We want to avoid guardianship where it's possible. But there are people who need guardianship, and we know that. There are many of you on this webinar, your child or your loved one needs a guardianship, and we know that, and we're not suggesting they should not have one. But there are individuals that would qualify to either not have a guardianship and not be under that paradigm, or there should be a supported decision maker that is an adjunct to the guardianship in that guardianship court where the person has a formal recognition of their greater right of self-determination, even under guardianship. Okay, I'm now going to launch into the review of the legislation. I hope what I've laid out is something that you can think about in the days and weeks ahead. So Jeff, let's get into the new legislation now. And my goal here is really just to convey the breadth of this legislation. When I first sat with this, and I encourage you to do so, it won't take long for you to read it. I remember just this epiphany that I had, just being overwhelmed with the sheer magnitude of this conceptually. Again, a very simple concept, but the sheer magnitude of the scope of the legislation, it took my breath away, to be honest with you, going from having this old paradigm to now having this just tremendously broad legislation. And I'm going to let you decide whether that's a good thing. I know the disability community at large believes it's a good thing, but it will present challenges as we try to figure out how to deal with it and how to think about it. So the supported decision making is defined, okay, as something that can happen. A supporter can be appointed with or without a written agreement. The supported decision maker doesn't have to be just one person and one relationship. It can be a series of relationships. Hard to get our minds around that. It is the ability to make and communicate and effectuate the person's own life decisions. Now, again, as I just mentioned, this whole notion of a supporter has to do with supporter or supporters, plural. And it has to do with all kinds of parameters of how the supported decision maker is there to help the person make their own decisions and further the rights of the adult. And it outlines the responsibilities of the supporter. Okay, Jeff? And the supporter is a person selected by the adult, and that supporter has to provide support. And again, as I had defined it in my own way, the supporter is to provide support in helping that person make their own decisions, communicating their own life decisions. Okay, Jeff. To assist adults, what is the purpose? The purpose is to assist the adult by obtaining support in making, communicating, or effectuating their own decisions, preferences, and choices. And to prevent, and this is very interesting to me, to prevent the appointment of a substitute decision maker. And remember, we're talking about a very broad concept here. Some people will understand their rights, some people won't. Some people that don't understand their rights will have to have others be advocates for their rights, as you always have been. But this is not the appointment of a substitute decision maker. It is someone to help the person effectuate their own choices. Okay, Jeff. Now, what are the goals and applications? To increase the adult's self-determination. We've talked about that. To prevent the substitute decision maker unless it's really needed, okay? A new test, a new standard, a new paradigm. To limit or terminate the use of the substitute decision maker. So that's getting to the issue what some of you have been thinking about this morning and talking about is, do I need to have the guardianship terminated? What do I do here to think about this? Well, here it is, to limit or terminate the use of the substitute decision maker. This is breathtaking when you think about this. All adults, in all caps, all adults are presumed capable of making an SDM agreement, either verbally or in writing. Can you imagine? All adults. So we have a brand new paradigm of what guardianship was versus what it is. We have a whole new paradigm of what individual rights is. And the legislation literally says that this is to be construed liberally. All right, Jeff, I'm going to let the audience think about that one. Now, manner of communication, okay? This is not a ground for determining the adult's capability. I want you to think about this one. For making, changing, or revoking the agreement. So no matter how a person communicates, some of them are verbal, some of those folks are nonverbal that we know. No matter how they communicate, this is not a ground or an excuse or a reason for saying that person, because they communicate that way, they don't really have the ability to make an agreement. You see how broad this is? It can't be used as evidence of incapacity. Okay, it cannot be, and it cannot restrict the adult from acting independently. Okay, so you see these restrictions have been, they've been removed. Now, here we go with guardianship. A person under guardianship may enter into a supported decision-making agreement. The court may limit, now the court can limit this, the court may limit or remove the guardianship due to the existence, I should say, of the supported decision-making agreement. And the guardian, as you may have heard me mention prior to this, I mentioned that the guardian has to consent. Well, here it says the guardian cannot refuse without good cause. Now, there are going to be times and there's going to be instances where a person under guardianship won't have a supported decision maker. The court has the jurisdiction over this, but a guardian cannot say no without good cause. Okay, let's go to the next one, Jeff. Support, let's define that. Gathering information, understanding and interpreting information. Now we're talking about the supporter. We're talking about your loved one with disabilities, and here's the supporter. The supporter can gather, understand and interpret information, help the person weigh their options, help them understand the consequences, the pros and cons of a decision. They can participate in conversations with third parties, and they can help the adult in the implementation of a decision. But remember, they cannot make the decision. All right, Jeff? Now, what are the responsibilities of the supporter in addition to what their normal duties would be? Well, they have to support the person and their preferences without inserting their own opinions. And as some of you will see in this short film, there are people I've met along the way, wonderful supporters, people who are highly skilled in this particular area, and to see them in action and to see people like you in action as you support your own person and your life with disabilities is just amazing. To see them support the person without any kind of insertion of their own wishes or their own preferences, and really respect the rights of that person. It's a beautiful thing to see. They have to act honestly and diligently in good faith. They have to act within the scope of the supported decision-making agreement. And as was the concern of so many really wonderful attorneys who are trying to do the right thing and advocates, they have to maintain financial records. They have to maintain general records of the supporters' actions, how the adult communicates and expresses themselves, and maintain the safety and security of records, right? What if the supporter can no longer act as the supporter and there has to be a transition to another person? The law requires that they keep records. And the relationship between the principal, or I apologize, I said there was no agency relationship. So even people like me are falling into the old paradigm, and I have to be careful about that. So the person who is appointing a supporter, the person has new rights. That relationship is one of trust and confidence. Okay, let's go to the next slide, Jeff. Now, a supported decision maker may not, so let's look at this in reverse, again, being redundant, make decisions for the adult, exert undue influence on the adult, coerce the adult, obtain information about the adult without their consent, okay, enforce decisions made by the adult outside of the person's presence, unless authorized by them to do so, or act outside the authority of the supported decision-making agreement. So extremely broad new rights for the person with disabilities, and very clear limits of what the supporter's responsibilities are, what they can and cannot do. Okay, Jeff. Now, who cannot be a supporter? We know that the person with disabilities can appoint a supporter, but who may not be a supporter? Well, a minor, obviously, a very good thing. A person against whom the adult has a peace order. Well, that makes sense, right? A person who has been convicted of financial exploitation, okay? So those people obviously should not be and cannot be a supporter. Now, a supporter, as I just mentioned, could resign, or they may not be able to serve. So if they resign, it must be orally given or provided in writing. Now, you'll have to make your own decision about this, whether this is good enough. But the law is very broad that they can resign orally, and they must give in writing to all persons that are otherwise named as supporters. So what if there are successor supporters? This resignation has to be given to all of those persons and third parties who have the agreement in their files. Okay? And of course, the authority of the supporter ends if they themselves are incapacitated or die. Okay, Jeff, let's go to the next slide. Now, let's get into the supported decision-making agreement itself. Now, again, Maryland right now does not have a supported decision-making form that is available. Now, we at our firm, at Elville and Associates, we're creating our own form. We believe that that's the correct thing to do right now, and we will have that available to you if you would like to use a supported decision-making form which complies under Maryland law. But any form, and again, you'll see here that there's no strict rules on this. Any form that is consistent with the statute is acceptable. Okay. It must be documented, dated, and witnessed by two adults who are not the supporter or an employee or an agent of the supporter. It must name at least one supporter. It must describe the decision-making assistance that the person wants or needs. It needs to describe how supporters are working together or how they may work together, and any potential conflicts of interest and how those conflicts of interest can be dealt with. Okay, Jeff. It must document how the adult selected the supporter. Okay, that's interesting. It must be approved by the court if the adult has a guardianship, okay, and the supported decision-making agreement affects the authority of the guardian. And that's going to be the case, I think, in almost all guardianship cases. And it must contain an attestation about the adult's independence in decision-making, that there's a formal recognition that the adult under the statute maintains their independence in decision making, and the supporter agrees and understands that. Okay, Jeff? Now, the adult can actually revoke this at any time. And just like the supporter can resign orally or in writing, the revocation can be oral or in writing, okay? And the third party can rely on a supported decision-making agreement. Now, this is one of the concerns that we're going to have to work through. A lot of individuals who learn, the public at large, as they learn about supported decision-making, they're going to be concerned. Institutions and people in the public domain are going to be very concerned about, what does this mean to me? What is the liability to me where I'm dealing with someone who is in front of me who has a supporter? Well, these third parties can rely on the supported decision-making agreement in good faith. So you see the shift in the paradigm here. Now, third parties, interestingly, may decline to comply if they have knowledge, actual knowledge, that the form is invalid, that there's been a revocation or an abrogation, or the coercion or undue influence of the person by a supporter. So that's good common sense legislation there. But we are in this paradigm and shift, and we're dealing with a good faith application of the law, a good faith compliance with the law, and for purposes of this discussion, good faith and bad faith, whether or not the supporter is acting in good faith or not, and a person who is being presented with this shift, this person can make a decision. If they see this as an undue influence or coercive situation, they can refuse to comply. Okay, Jeff. Now, third parties that are, again, dealing with your loved ones with disabilities that have a supporter, they can be held liable for causing personal injury as a result of negligence or reckless acts, failing to give effect to the adult's decisions in accordance with a valid agreement. Now, for the person or the couple who asked the question, what is the difference between my already robust support and now having this agreement in place? This is one of the main things that I want you to focus on. A person who is presented with a supported decision-making agreement, or a supporter in support of a person with disabilities who fails to give effect to that decision, or that agreement, I should say, is in violation of the law and can be held liable. Okay. Failing to provide information to the adult or supporter of the adult that would be necessary for informed consent, and other actions by a third party that are inconsistent with the law. Okay, Jeff. Now, as we're getting toward the latter portion of the presentation, and I thank you for your attention as we've painstakingly worked through this, let's talk about how supported decision-making actually benefits persons living with disabilities, in addition to what we've described already. So, persons living with disabilities are no longer strictly limited by their diminished capacity. This is a paradigm of risk, and each person who is listening to this webinar, or each person in the state of Maryland who encounters this in this situation or this information, is going to have to interpret it for themselves, okay? This paradigm of risk and what it means to you and what it means to the persons with disabilities. And this paradigm of risk should encourage independence during a road to recovery if someone has been injured, say a brain injury or other incapacity that may be something that is going to improve for the person and they may regain capacity. It's a new empowerment and recognition of the continued rights of self-determination of a person with disabilities. It is a new and legally articulated role for supporters. And this again goes back to the question that was asked, what is the difference between yesterday I should say, and today? Well, today, this is a newly articulated path forward. It is a psychological shift, okay? Supported decision-making conceptually should not be pigeonholed into one particular application. It should be interpreted broadly, but as the person with disabilities now has risks and is allowed to take risks, the public at large and parents and supporters now are going to have to deal with what this risk means in your own lives as you work to continue to support your loved one. Ideals of independence and rights of self-determination are not diminished. Okay, that's a huge thing in my mind, coming from the old school of my many years as an attorney. What that means is, remember that under guardianship, a person can have a supported decision maker now. So even if there is a real need for guardianship, a really substantive and real need, the person, they're not fully going to lose their rights as long as the court deems and the guardian allows and agrees to the person having a supported decision maker. So their independence and self-determination is not completely extinguished. And again, these are new protections from strict application of guardianship. Okay, Jeff. So as we start to wrap up here, and we are just starting this series of presentations on supported decision making, so we're not going to be going as long as we sometimes do, and that means we're going to wrap up here in probably about an hour and 15 minutes instead of our normal hour and a half. To suggest a path forward about this, we are here to help you. We're here to be a resource. We want you to think about what this means to you. We want you to relax. If this is confusing, as I have found it is with some audiences that are very devoted persons or organizations to the ideal of supporting those with disabilities, I want you to relax and understand this is going to take a little bit of getting used to for some people, not all. And I want you to develop your questions. I want you to come talk to us. We can help put a supported decision-making agreement together. We can help counsel about whether we should proceed with the termination of guardianships under certain circumstances, or the crafting of new guardianship orders, modifications of guardianship orders, where it's desired to have a supported decision maker under guardianship. And on the other end of the spectrum, to evaluate the capacity of those with disabilities so that we can implement, where appropriate, powers of attorney, advanced medical directives, and a supported decision-making agreement where the person has two things. They have incapacity planning if they cannot make their own decisions, and they have a supporter to help them actually make their own decisions to whatever extent they can make those decisions, provided they have the support to do so. We want you to have an advisory team. If you're looking at these issues, if you're looking at special needs planning, if you're looking at your own estate planning, we want you to have a team of advisors, CPAs, financial advisors, and if you already have a team of advisors, we want to get to know them. We want them all to communicate so you can achieve perfection in your planning. We want you to have time to think. We know many of you who are on this webinar are extremely busy, overwhelmed, taking care of your loved ones with disabilities, and you don't always have that time to think. So we want to give you that time and be a resource to you. And again, as I mentioned, we want to help you think through this very simple concept, but actually very complex concept, considering the variety of situations that each of you have and what it means to you and your loved one with disabilities, and helping you design an agreement that works for you. So Jeff, with that, I'm going to say thank you to everyone. Appreciate your time and attention. I am so privileged again to present with Jeff here and bring this to you. I'm going to stop and just turn it over to Jeff for questions, and thank you for your time this morning. Jeff, we can't hear you, I think.
Oh my, sorry about that.
That's all right.
Sorry about that. Want to thank you, Steve, for a great presentation on such an important and powerful topic, and something that's going to affect so many people in, I think, a positive manner as we move forward here and continue to understand the new law, and we'll keep people informed and have more of these presentations as we go forward. So we do have some additional questions here that I want to make sure we get to, and I'm going to scroll up here. Looks like we have several of them here. I don't want to miss them. Let's see here. Bear with me just one second. Okay, here we go. How do you begin the process for establishing SDM agreements if there are no POA or advanced directives in place?
Thank you for that question. I would say the best path forward is just to set an appointment where we can get to know you and your family situation and the situation with your loved one with disabilities and really evaluate that from a legal perspective. And then we can advise and get to know about that person's capacity or level of capacity versus on this continuum of powers of attorney and advance directives all the way through the middle of supported decision making, all the way to the spectrum of guardianship, and really try to make the best path forward and choices. That's where I would begin with this process of evaluation.
Okay. Next question, doesn't listing my other son as a replacement power of attorney and healthcare proxy do that? I'm not sure what that refers to, but maybe you can expand upon that.
Thank you. If I can extrapolate on what I think your question is, and I could be wrong, but let's just go with my thought about this. If you're suggesting that you've named your son, your other child, as a successor agent under a financial or advanced medical directive power of attorney, what I think you're asking is, doesn't that suffice for saying, well, this person, my son, would have the first order of priority as a supported decision maker? And I think logically, yes, the answer would be yes, but it is not a substitute for supported decision making, because if you desire your son, or I should rephrase that, if your loved one with disabilities desires your son to be a secondary agent and a secondary supported decision maker in the order of priority after you, then I think that's a completely separate issue. Meaning, if we wanted to put that in writing, we're going to need to list your other son as a successor supported decision maker in a supported decision making agreement. Now, on the other hand, if we look at the law very carefully, we see that your loved one with disabilities can appoint your other son verbally as his supported decision maker. So I think this is just a question of whether or not we want to formalize this in a writing, which is an actual written supported decision-making agreement, versus rely on the verbal aspects of the law to provide a secondary supporter such as your second son.
Okay. Next question, who determines the need for guardianship?
Thank you. That is a question that has to do with the court being the circuit court in Maryland, not the district court, but the circuit court level. The judge, meaning the court itself, would evaluate physician certificates. So if you were to petition for guardianship of your loved one, you would have to submit 2 physician certificates showing that your loved one with disabilities did not have the mental capacity, and a very general description here, did not have the mental capacity to make their own decisions or appreciate the nature of guardianship. So you petition the court, and the court, through a process, which we will be happy to explain to you outside of this webinar, the court actually evaluates testimony or whatever other evidence as to whether your loved one needs a guardianship of the person or property. They are supposed to, and now under the new law, will much more likely to examine all lesser restrictive alternatives to guardianship, including supported decision making. But it's a process of the court evaluating and making an assessment as a decision as to whether guardianship is needed and awarding guardianship or not.
Okay. How does this assist individuals with dementia and memory recall issues, especially if POA advanced directives have not been put in place and memory loss has progressed?
I thank you for that wonderful question. We are very early on, and we don't know exactly how this is going to play out and how the state of Maryland will interpret this very broad platform that people with disabilities have been given. But in your particular scenario that you're describing, I will go back to my basic definition. Persons with disabilities, and that would include, in my opinion, the person you're describing with dementia or diminished capacity. Persons with disabilities have the right, very broadly defined, to make their own decisions, direct their own lives to whatever extent possible that they can do so, whether that's a great extent or a small extent, provided that they have the support to do so. So in my opinion, a person with diminished capacity, subject to lots of other evaluation, and but as a basic paradigm, nonetheless has in concept the right to make their own decisions, even if those decisions are very small in the eyes of others, provided that they have the support to do so.
Okay. I think this next question may be along the lines of your previous answer here. Says, I'm confused a little. My daughter is under guardianship of the person in Maryland. She is not able to make financial decisions or medical decisions due to her intellectual disabilities. We did this to keep her safe. Many of my friends didn't seek guardianship for their children because of the limitations. We, of course, support her and give her as much freedom to exercise her rights and her choices. She will always need guidance and support. Her condition is permanent. What should we do? Can we have both? Do we have to return to the courts? And what about as we age and need someone else to be her guardian?
Well, thank you for that lovely and wonderful question. Well put. That is exactly what my very short film is about, to help you think through this dilemma and to show the world the dilemma that a person like you is very much dealing with this. So very simply, supported decision making may not be for your child. You are the guardians of your child's person and property from what you've described, and you might have very good reasons not to want her or need her to be able to appoint a supported decision maker, which obviously you would be that person if the court allowed the appointment of a supported decision maker. So this gets to the very crux of the issue, where you're providing this wonderful support and your child is very lucky. There's a guardianship that you feel is very necessary for her protection, and you're probably 100% right about that based on what you're saying. But the right exists. Whether or not it's right for your child is something that you'll decide as the guardian and that the court would decide. So here's where this continuum now, there used to be this particular mountain over here and this particular mountain, and that's where we were, and there was nothing in between. But now we have this continuum from one extreme to the other, and you're going to decide where you want to be and where you are on that continuum. So there are no good answers, only the examination of these concepts, the hearts and minds of people like you who have guardianship, and whether or not you feel it's the right thing to establish this notion of supported decision making inside of the guardianship for the future generations, meaning after you are no longer here. Even though right now you're providing all that support, there might be an argument that you'd want to implement it for your child, even so it's already in place, or so it's already in place as we go forward, versus no, we don't need it at all and we don't think it's going to help. So again, only you will know that, and we could parse that out in more counseling.
Okay. What is the liability of a good faith supporter if the principal's choices have negative consequences?
Thank you for that wonderful question. My answer to that is it remains to be seen. However, if we look at the law, if a person who is the supporter is acting within the scope of the law and they're acting within the scope of the supported decision-making agreement, they would not have liability, although this is a concern, and you can see all of the potential issues that are raised by the new law. This is one of them. But if ideally, the person is acting within the scope of the agreement. So if the person makes a choice that is not something you would think is the right thing to do, they have the right to fail. I would think, again, we have to see how this is going to be applied. I would think that if you are seeing a person make a decision that is going to harm them in a real serious way, harm them in a physical way, or put them at risk of undue influence, then perhaps what's going to play out in the law is that there is a right to intervention. But I think as long as we are confident in our operating within the scope of the agreement, and I think as long as we're confident that the person's choices are what I would call routine choices, that they have the right to fail, they have the right to make the wrong decision, they have the right to be hurt by something, I think it's just going to be a matter of degree. And for example, in the law, we as lawyers, we are held by rules of professional responsibility. And there are clear rules that sometimes get very blurred, by the way, about when we are allowed to intervene in a situation. But those tend to be very extreme situations where the right to confidentiality gives way to, or the right of the responsibilities, I should say, to refrain from such things give way to the responsibility to intervene. And I think as this plays out, more of those lines will be clearer.
Okay. Next question. This is the lady from Florida again. As somebody with a physical disability, I understand what you're saying, and I wonder if there is training for people who support people with disabilities in making decisions. I am not at that point yet, but I just wanted to share my experience as someone who has been legally blind for the past 20 years. And for example, if I hire somebody to read my mail to me, somehow they think that they have to give me financial advice or tell me how or when to pay my bills or what to purchase, etc. And they don't seem to understand that I'm just hiring them to read for me because I cannot read printed material because of my vision. I don't need their help in making my decisions. How do you deal with that type of thing?
Well, thank you. Again, I can't advise legally for Florida or in any way on this webinar, but my initial reaction is to say that the person you hire would not necessarily be a person under a supported decision-making agreement that is your supporter. So I think you need to make a distinction between the person who you hire versus a person who you say, I am appointing you as my supported decision maker under whatever state law it is, and also whether or not that person has signed an agreement with you, depending on the rules of Florida and whether Florida has supported decision making. So the first thing I would do is make a distinction between someone you hire and an actual supported decision maker. The second thing I would do is I would look at your state's websites and so forth about supported decision making and whether Florida has that, which I'm pretty confident it probably does, and see the training videos that are on there. And then once you have, appointed your supported decision maker, make it a point of them having to watch those videos. And many states such as Alaska and Indiana and those kinds of states have wonderful videos about how this works. And Maryland now has the first of what I'm sure are many videos that are to come on the judiciary website about alternatives to guardianship and supported decision making video there.
Okay. Is this required in the case of guardianship? Our 25-year-old son is severely autistic and has trouble making any decisions, including what to eat for lunch. He is under a guardianship where his father and I are guardians of the property and person.
Wonderful question. Thank you. The answer is no, it is not required. And so that's a great example of someone who, like yourselves, who are the guardians of the person and property. And maybe your initial reaction is going to be, well, what does this mean to us? And why would we want this given the circumstances? So it is not required. I would look at it as if I were you, as a tool. It is a tool for courts and the legal system. It is also a tool for our society and for persons to achieve a better right of self-determination, much broader. But again, your situation may be such that supported decision making doesn't make sense, even though conceptually it exists for your child.
Okay. A supporter may be needed for the life of the person with a disability. How do supporters get named over the next number of years, perhaps 50 years?
Wonderful question. Thank you for that. These kind of questions are really helping our presentation today. I'm going to say that the best way to think about this in my reaction to that question is the same thing we tell individuals that are doing estate planning. Many people look at estate planning, for example, and they feel a lot of pressure about having to make all the right decisions today. And they feel a tremendous amount of pressure about the future. And I always like to tell clients, please don't think about it that way. It's very human to think about it that way. But we want to think about putting the best supporters or the best estate plan, for example, in place today, and understanding that it is not forever. This estate plan can be reviewed 2 years later. It can be changed. Agents can be changed. Supporters under supported decision-making agreements can be changed, but not to think in terms of the next 50 years, even though I know the nature of your question. So the answer is, we want to look at, in my opinion, supported decision-making similar to estate planning. The person with supporters can review that agreement as often as they want, change it as often as they want. And the only thing that we can do to help the person make their own decisions is to list as many people that are reasonable to list in that supported decision-making agreement, knowing that over the years to come, it can be changed, it can be reviewed. The person can be asked whether or not they're happy with their supporters and whether they want to make changes at any time. And then in the future, and I know that's very scary, the future when you are no longer here, or the listed supporters are no longer here, that person will maintain, under the current law, they will maintain their right to appoint new supporters verbally or in writing. And we have to trust as that society is going to continue this trend of support that allow that person to continue to have that ability and to help them do so.
Okay, so we have a few more here and then we'll close out here for the day. If we have a power of attorney, the third parties or providers can't just legally ignore that document either. So I'm still not seeing how having a power of attorney and using supported decision-making process without an actual agreement helps us. In fact, it seems to contradict the provisions of the power of attorney, which let us make a decision for our son if he is doing something harmful, like insisting on living all by himself, which he isn't able to safely do.
Thank you, and thank you for that question. So this, again, is a wonderful segue into how this law can create confusion, ambiguity, and what do we do with this? And I couldn't agree with you more. And I'm not in your shoes, and I can't experience exactly what you're feeling about this, but I would say, stepping back and looking at the purpose of the power of attorney, remember, the purpose of the power of attorney is for your child to appoint you as his agent, and therefore you can act for him if he can't do it himself. Now, you obviously are already doing that. So you are in a position of an agency relationship with him. And in your particular family, this may be perfectly fine. Your son hopefully is very happy with his own life and with you as his agent. This is just adding a different layer to allow him to also appoint you as his supported decision maker, which only you know whether that's what you want and what he will want. That little shift gives him greater rights than in a sense, in the sense that there's a formal recognition of his right to have you help him make his own decisions. And practically speaking, as you're describing, that may not make a lot of sense in the day-to-day world of what you're dealing with. So again, this is part of the whole thrust of what I was saying throughout the presentation and at the beginning. Only you are going to be able to sit with this information and decide what it means to you and whether it's useful to you and your child. But in theory and in concept, it is putting your child in a different universe of personal rights and the recognition of those rights, even though practically speaking in the day-to-day of what you're dealing with, it may or may not make any difference in how you see it best to support your son.
Very well said. Does Maryland DDA issue any guidance on supported decision-making?
That is a great question. I have to honestly say I don't know, but I'm going to venture to say that they either are doing that at this point, and we can find out and get back to you if you could email us. And if they're not doing that, they most surely will be, because the tremendous advocates for supported decision-making, like Megan Rusiano, are very active in giving presentations and providing support to organizations and state agencies. So I'm pretty confident that they will be giving support or guidance, at least in the sense of education.
Okay. SDM seems to have legally recognized shades of gray, the continuum of a person's abilities to self-determine. Who determines adequate competence to self-determine?
Wonderful question, and I'm going to just describe it the best way I can, and then leave you to your own evaluation and your own research and listening to other experts or experts beyond my scope about this concept. The way I would think about that is that a person with disabilities is deemed to have this right or this ability, no matter what their level of disability is. So the purpose of that, as others will maybe more articulately set forth, is to remove the barriers, remove the limitations, and take a leapfrog away from the old paradigm. So it's a concept that's so broad that it's very hard to think through. But my answer to that is, in concept, in theory, a person with any bare minimum level of capacity is deemed to be able, to whatever extent they can, to not only recognize a supporter and name a supporter, but to make a simple decision, exercise some level of legal capacity, even if it's just, I want to go to a ball game and I would like to buy a hot dog. So again, I have to leave you to your own thoughts about this because it's so broad. I apologize, I'm not able to articulate it better than that.
Okay, I am the rep payee for my daughter. How will Social Security recognize this new law? My daughter can't handle her own money and is easily taken advantage of since she is vulnerable.
Thank you for that. And I would just say, to my knowledge, and this may be proven differently in the future, to my knowledge, this will not affect your status with Social Security as a representative payee, because that is in and of itself avoids guardianship and is something that the very large Social Security Administration has recognized for years. And I have not heard or seen anything that would say that's going to change.
Okay, so is it the attorney who advises what is legally appropriate for any given individual if they have capacity SDM agreements? Hope that makes sense.
Yeah, so that's a wonderful question, and I'm going to extrapolate again in the interest of time and just say the attorney will advise and advise as to the scope and advise if we are putting something in writing, whether that meets the spirit of the law and the provisions of the law in the agreement. But the attorney can judge legal capacity from a legal perspective, not from a medical perspective. And this is a very hard thing to understand as well. So attorneys are trained to judge and determine the capacity to execute documents in a sense of a legal determination, not a medical determination, although the medical kind of melds in certain ways. So to my knowledge, as we are in the early days of supported decision making, the attorney will not have the ability, and this is preliminary now, the attorney will not have the ability or the authority to say that a person does not have the mental capacity to execute a supported decision making unless that inability is very, very evident. So again, the law has taken the lid off of this whole situation of the old paradigm and made it so broad that we are going to have to see in the months and weeks ahead and the years ahead how this plays out. But to me, there will be times when it will be very clear that a person does not have the ability to understand how to name a supporter or what the nature of supported decision making is. But the law attempts to remove the old paradigm of the physician statements and the definition traditionally of incapacity. So it'll be very fluid, not only in the law, but very fluid in that situation, in my opinion.
Okay, we've reached our last question here. How does one go about setting up a designated person/team to help make medical/healthcare decisions specifically? Is this through a power of attorney or advanced medical directive?
Thank you for that. As we wrap up, wonderful question. I think what you're asking is if I create an advanced medical directive and I'm naming my agents, which is obviously one of the major aspects of an advanced directive, you can also build a team. So in an advanced medical directive, you can actually say, well, these are my agents, and if this person can't serve, then this person will serve. These are my successors. But you also could put in there and highly design this, and say that a person should be consulted with. When my agent is making decisions, they must consult with this other person who might be a nurse or a life care manager or a doctor or another family member or the other agents. So you can create that team and that decision-making structure inside of the advanced directive. And that's just a matter of sitting and quietly thinking about it and structuring it in the right way and interviewing the right people that share your values.
Okay. Well, thank you for all those really great questions. This is obviously a topic that is very important to a lot of people. It's important to us here at Elville and Associates. Steve, thank you for a great presentation,
Thank you.
and we'll
Thank
be
you.
doing a lot more of these. I have a lot of follow-up for you, our attendees, including I'll be sending out today's video that you can review. I'll be sending out the slides and those sample support decision-making agreements to you again. I'll send out a link to Steve's article he wrote about supported decision-making, as well as the video that he made about supported decision-making as well, along with a list of some of our upcoming webinars as part of our ongoing Elville webinar series. So a lot of things to think about, obviously. Let us know how we can help you. If you'd like to set a time to meet with Steve to discuss this important topic and how it fits into your family's dynamics, and we'll always be happy to be a resource to you here at Elville and Associates. So thank you for spending some time with us this morning. We look forward to seeing you again soon, and thank you for being part of the Elville webinar series. Have a wonderful day, everybody, and we'll see you again soon.